The scheduled caste status lies at the intersection of constitutional angle and lived social reality. In India, this is deeply intertwined with religion of the person. But is that the right way to go? Or now is the time for change? Hello students, welcome to Drishti IAS. My name is Saloni Nandhyoliar. In this session, we are going to talk about the recent judgment of the Honorable Supreme Court of India, where certain remarks have been made which have raised a controversy, a debate around the link between the scheduled caste status of a person and the religion of that person. So let's get started and see what happened over here. So the Honorable Supreme Court of India, while listening to a plea, upheld Andhra Pradesh High Court's judgment, wherein the Andhra Pradesh High Court had said that any person belonging to the scheduled caste community loses his SC status immediately and completely upon conversion to another religion. So the court here said that if there is a person who originally belonged to Hinduism, Sikhism, or Buddhism has converted to any other religion, they will cease to have their scheduled caste identity. If they originally belong to a scheduled caste category in either of these religions, if they convert to any other religion, let's say Christianity or Islam, they are going to lose their scheduled caste status. That's exactly what happened over here in this case also, that there was this person who originally belonged to the scheduled caste community. Now the person converted to Christianity and they started acting as a pastor. But they alleged that certain offenses were being made against them. So he wanted to invoke the SCST Prevention of Atrocities Act. He was demanding protection against the SCST Act. That is when the High Court said that no, you cannot demand such protection because the moment you converted to any other religion other than Hinduism, Buddhism, or Sikhism, you have ceased to have your scheduled caste status. You're no longer a scheduled caste person. So that is why this cannot be invoked. This act cannot be invoked. And the Supreme Court of India also upheld the very same decision. But this has sparked a different debate. Is the lived reality of the person going to remain the same, or will it actually change once conversion happens? If a person who originally belonged to the scheduled caste community, when that person converts to any other religion, will the discrimination cease to end? So these are certain questions that are being asked by the experts. So in this video, we are going to analyze the legal angle, the constitutional angle, and most importantly, the social angle. So let's talk about the legal angle, which law is governing all these things. So there is this order of 1950, which is called the Constitution Scheduled Caste Order of 1950, which says that any person who originally was a Hindu, if he or she converts to any other religion, they will cease to have their scheduled caste status. The order of 1950 only included Hindus, but in 1956, we added Sikhs to it. And in 1990, we also added Buddhists. One of the popular reasons behind the addition of Buddhists in 1990 was Dr. B.R. Ambedkar's conversion to Buddhism. So this is also one of the reasons that is cited behind adding Buddhists to this category. But right now, this order says that if there's any person who is converted from Hinduism, Buddhism, or Sikhism to any other religion, they will cease to have their scheduled caste status, and they cannot have any other special provisions or reservations that are granted to the scheduled caste. Those things will not be applicable to these converts. So this is the legal angle. Legally, nothing's wrong with it. Nothing is wrong with the judgment of the Honorable Supreme Court because no laws are being broken over here. Legally, everything is fine. But if we talk of the constitutional angle, and most importantly, the bar here is absolute and it admits no exception. This is also a unique thing of this law, that this bar is absolute. There's going to be no exception, no case-by-case basis judgment is going to come out because there's no exception. It's an absolute thing, and a person who has converted will not have scheduled caste benefits. Now, if you look at the constitutional angle, so in the Constitution of India, scheduled castes have been talked about under Article 341, right? So what does the Article 341 of the Indian Constitution say? It says that the President of India can notify SCs in states and UTs. So the President is going to notify SCs in states and UTs, and the Parliament can modify it if need be. the parliament can modify it. So who's going to notify? The president. Who can modify? The parliament. Can the states do anything in this? No. States do not have this power. So the list of SCs in any state or UT is notified by the President of India. And if the Parliament feels there can be any modifications that can be made to that list. All of this is given under Article 341 of the Constitution. And why do we have these backward classes or the provision of identifying people as scheduled castes or scheduled tribes? Because we want to grant them special protection because they have faced oppression and discrimination in the past. Even pre-independence, there was a concept of depressed classes, Harijans, Dalits, and that has been continuing till date. And the court's angle actually behind this entire judgment was that this entire category or this entire discrimination against the depressed classes, against Dalits, this originally belonged to Hinduism only. This belonged only to Hinduism. It was not a practice that was common in Christianity or Islam or any other religion. It was predominantly common in Hinduism, and after later on we also added Sikhism and Buddhism to this list. This is the court's angle, that the concept of such caste-based discrimination is not very prevalent or has not been very prevalent historically in other religions as it has been in Hinduism. This is the court's angle. Now, because this oppression has been ongoing for all the scheduled caste people, the motive post-independence has been to provide them special protection. For that, we have certain articles like Article 15, Clause 4, where we talk of some special provision, special protection to the scheduled caste. Then we also have Article 16, Clause 4, which talks about what? It talks about reservation in jobs. Reservation in jobs. We also have Article 17. Article 17, that is against untouchability, right? So these are some protections that have been provided, or certain reservations, certain benefits that have been provided to the scheduled caste communities in India because historically they have been oppressed. But the center of the debate or the core of the debate over here is with reference to Article 25. Article 25 of the Indian Constitution, which gives every citizen the right to propagate, profess any religion that they want. This is applicable even to the converts, which means that any citizen of India can choose their religion. Originally, they might have been born in a Hindu family or in a Buddhist family, but they can choose to profess any religion that they want. This is a fundamental right, correct? It is a fundamental right, but as soon as a scheduled caste person of, let's say, Hinduism, Buddhism or Sikhism chooses to be a convert, chooses to convert into any other religion, they are ceasing to have all the provisions or all the protection under the SC status. So they will have to let go of the SC status, and letting go of the SC status also means letting go of all the benefits, letting go of all the reservation, of all the protection that is coming along with it. So this is the center of the debate, that if the Constitution of India allows me to practice any religion, then in that case, whenever a person converts into any other religion, is the ground reality going to differ for him? Is the lived reality going to differ for him? And that exactly is the basis of the sociological angle. If a person for decades has faced this kind of an oppression or discrimination in the early years of his or her life because they belong to a scheduled caste, tomorrow if they decide to convert into any other religion, will that change? Will the lived reality of that person change? This is the question that the critics are asking, that the experts are asking, that will the lived reality or the ground reality of the person change once they convert? Will they no longer face that oppression? Will they no longer face that discrimination once they convert? And in fact, this was something that was raised. This was a question that was raised even by the Kaka Kalelkar Commission. Kaka Kalelkar Commission also raised this very important question. This was formed under Article 340. And they also raised very important question. In fact, the report that they submitted, one of the main recommendations here was that caste should be caste should be the basis. Caste should be the basis of deciding all these benefits, of all these reservation, etc. So whenever it should not basically be linked with religion. So if a person belonging to a scheduled caste, even if the person converts to any other religion, if the person originally belonged to the scheduled caste, he should not be letting go of all the benefits or all the reservation that was being provided to him, because the lived reality of that person is not going to change. The ground reality of that person is not going to change. So caste should be the primary factor, should be the driving factor in deciding what kind of benefits are going to be there, and religion should not be that factor. So this is something that the Kaka Kalelkar committee also recommended, but it was not accepted because the government felt that there is an over dependence on caste in this case. So the government did not accept this, and this is what's happening in India at the moment also. Right now, the social status or the scheduled caste status of a person is deeply intertwined with the religion of that person. If the person is no longer a Hindu, Buddhist or Sikh, the person will not enjoy the SC status. And this is the debate, this is the entire controversy where the experts are raising these important questions. So it is upon the judiciary, it is upon the government to decide if this is the need of the hour to actually change this, or is it absolutely fine, should we continue with the same practice or not. But that was the end of this discussion, and hope you enjoyed everything that we discussed over here. Now we'll look at a practice question. Before we do that, you know that we have this sale for you, which is the Selection Mahotsav sale, where you're going to get up to 50% off on all our online courses, pen drive courses and test series, and a 25% off on books, DLP and magazine. So the sale is live and will remain so till 26th of March. So please go ahead, enroll yourself in any course that you like, and if you have any queries, you can call us at this number 87501 87501, and you can also download the Drishti Learning app. Now let's look at our prelims practice question. Consider the following statements regarding scheduled caste status and reservation in India. 1. Under Article 341, the President notifies scheduled castes subject to parliamentary law. 2. A person belonging to a scheduled caste retains SC status even after converting to any religion. 3. Reservation in public employment for SCs is provided under Article 16, Clause 4. 4. The Constitution Scheduled Caste Order 1950 currently allows SC status only for Hindus, Sikhs and Buddhists. Choose the correct statements. A. 1 and 2 only. B. 2 and 3 only. C. 1, 3 and 4 only. Or D. 1 and 4 only. Please attempt this question and provide your answers in the comment section. Thank you for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.